All right, I am back. I am your host, Indigenous Hebrew Israelite, and today we're going to be discussing the Dred Scott decision. And if you could see the title, it's Democracy and a Republic here. So, a democracy and a republic. So, we're going to recap this here Dred Scott decision, which arbitrarily kept people of color, as Mr. Scott here, you can see him there, yeah, as Mr. Scott here, was kept in slavery in 1857. So they decided that in 1857 they was going to keep Mr. Dred Scott here in slavery based upon constitutional law. And as you can see here, this newspaper clipping was upon the opinion of Chief Justice Roger B. Taney, with an introduction by Dr. J.H. Van Every, I believe that's how it's pronounced, and also an appendix by Sam A. Cartwright, medical doctor, MD, medical doctor of New Orleans. I need you guys to understand that when they say that they need to study for reparations, you guys can use this clipping right here. This clipping right here this is a doctor. So this is the Chief Justice, the legal justice of the United States. And right here, this is a doctor, Cartwright, Dr. Cartwright, right, MD. So there's already been a study. They don't need to study black people anymore. But here we go. The natural history of the prognathous race of mankind. And this word prognathous just means that his lower jawbone is just more out. As you can see here, Chief Justice Taney, his jawbone is more inward. So that's the European type, and the prognathous is the Negro type. And there's something I want you guys to see at the bottom of this. So we'll read this real quick. The great want of a brief pamphlet containing the famous decision of Chief Justice Taney in a celebration of Dred Scott case has induced the publishers of the Daybook to present this edition to the public. So they're giving this information to the public. It contains a historical introduction by Dr. Van Every, author of Negroes and Negro Slavery. Remember that. These guys they're well studied on Negroes. And again, it goes on to say about Dr. Cartwright of New Orleans. But when we get down here to this part, this is what you guys need to understand. In order to place it before the masses, that's the public, and induce democratic clubs, democratic town committees. Now, this word democratic is not in the Constitution. Okay? Y'all remember that while we're in this discussion. Democratic is not in the Constitution. But this Chief Justice Chaney, that's his job to, democratically keep this guy here, Dred Scott, in slavery. When we go to Dred Scott, this Dred Scott case, let's go to the Dred Scott case real quick. We go to this Dred Scott case, and this is the opinion of the court. The Dred Scott case upon writ of error to a circuit court of the United States. So this is federal. This is federal court case. In the circuit court, right here is section 1, paragraph 3. In the circuit court of the United States, the record must show that the case is one in which, by the Constitution and laws of the United States, the court had jurisdiction. So that's the first thing they have to find in a court case, if the court has jurisdiction. And then paragraph 4 here says, a free Negro of the African race, or whose ancestors were brought to this country and sold as slaves, is not a citizen. Again, read that again so you guys are sure. So you guys get it. A free Negro of the African race whose ancestors were brought to this country and sold as slaves is not a citizen within the meaning of the Constitution of the United States. Y'all get that? Y'all need to understand that. This is what they're saying in 1857. And you can find this is the December term of 1856, the Dred Scott versus Stanford. These are all public records. So if you're not a citizen, and before I go on, it says a free Negro of the African race whose ancestors were brought to this country and sold as slaves. Now, I myself have ancestors from Africa. I have ancestors right here in the United States, American Indians, and I also have ancestors in Europe, which is something that's not being told to people of color. There were black people in Europe long before they started searching, the Europeans started searching Africa. There were black people in Europe. And that's one thing that won't be said in the United States here. They'll try to get rid of that history. And here we go. So back to this. So when you're in a court of law, as a black person, they're going to throw things at you, these democracy type stuff. They're going to throw these things at you. Being a citizen of the United States, they're going to tell you that the 14th Amendment protects you in all manners of whatever. They're going to tell you that 14th Amendment protects you, but it really does not if you're dealing with a law system that allows itself to lie to you or to take itself out of common law and put itself into a protective. Hold on one second. Okay, so these guys are going to put themselves in a protective situation to where the police can lie to you, or I guess officials in government can lie with impunity or lie with immunity. They can lie to you. And then it's the justice system that's actually protecting them. And we'll go down here to the decision of Warren versus District of Columbia. Now, this situation, it was a couple of women who were trying to sue Washington, D.C. police because they didn't get there in time. The police didn't get there in time to protect them. And this court right here, federal court, is saying that the District of Columbia appeals and affirm the trial courts, the lower courts, and dismiss their cases because there's no constitutional right. There's no constitutional right for the police to actually, save you. There's no duty. It says right here, the public duty doctrine ruling that the duty to provide public service is owed to the public at large and not a special relationship or not to an individual person. Okay? So the police don't have to protect you as a citizen. Here's another case here, the town of Castle Rock versus Gonzales. Now this one, the town of Castle Rock versus Gonzales. This one right here, this Supreme Court case actually went and superseded the 42 U.S.C. subsection 1983. And what that really is, as it's codified here, what that really is it's the KKK Act. It's the KKK Act that actually helped former slaves and their descendants to get around the states' rights. Because, again, you have a culture of black codes, people who are using black codes to systematically destroy black people living as civilians here in the United States. So again, this Castle Rock versus Gonzales, and it was decided in 2005. The Supreme Court overruled the KKK Act just so that they can protect, here's the holding right here. It says that they can protect the holding of this case, it says that the town of Castle Rock, Colorado, and its police department could not be sued under 42 U.S.C. subsection 1983 for failure to enforce a restraining order against respondent's husband, as enforcement of the restraining order does not constitute, it does not constitute a property right. Remember, Negroes were property. Negroes were property. It doesn't constitute a property right. Let's finish it. For the 14th Amendment process. Again, so one more time, this Castle Rock versus Gonzales in 2005, it is protecting the police from pretty much helping people. And you can look at any of one of your states' rights, or one of your states where they have laws where citizens must assist the arrest for police officers. They don't want to help here, but citizens are told to help police officers make an arrest if they can assist police officers. Don't make sense to me. It shouldn't make sense to you. But let's keep going. I think this was another case. We'll skip that one. And again, the 42 U.S. Code 1983, civil action for deprivation of rights. Now, again, this is something that was made up for, in the time when people were slaves, were made free. So it was made for freed men, as the word applies. Every person, and we'll read it here, the deprivation of rights. Every person under the color of any statute. One more time. Every person who under the color, remember that, of any statute, ordinance, regulation, custom, or usage of any state or territory or the District of Columbia, subjects or causes to be subjected. Again, under the color of law, under the color of any statute. Let's go find that out. Now, this is what the Supreme Court, they circumnavigated this right here for the police officers. Now, let's go figure out what a color of law is, or a color of any statute. Let's figure out what that is. We'll come back to that. The color of law, under color of law. Now, in the 1800s, they knew this as black codes, but you're not supposed to know that under the color of law is what they're actually doing today. See, they got rid of that 42. They got rid of this 42 U.S. Code 1983 to help the police. But under the color of law, you need to know this definition. In the United States Code, the term color of law describes and defines an action that has either a mere semblance of legal right, a semblance, like it's similar to a legal right, or the pretense of a right. Do y'all understand that? Do y'all get that? The color of law is a pretending right. It's a pretense. And you're supposed to believe that they got rid of this stuff, right? No. Under the color of law, they can bring those black codes right back at you while you sitting here in a democracy of a republic. But let's get to this real quick. The 14th Amendment in 1866 Congress voted to extend the Freedmen's Bureau, the Freedmen's Bureau, and passed the Civil Rights Bill to protect against black codes. This is what we're talking about here in a democracy of a republic. President Andrew Johnson, I believe he was the 17th president of the United States after Abraham Lincoln, who was assassinated. So President Johnson vetoed both bills, arguing that they violated states' rights. Y'all see that? Violated the states' rights. This is what the slaves are trying to get away from using the common law theory of Europe, I believe. Yeah, the common law theory. And common laws are basically human rights. But here, President Johnson, argued that these Freeman Buell Acts and civil rights violated the states' rights, and these states' rights were the Dixiecrats and all the Southern guys who wanted to maintain slavery or gross peonage. Congress overrode both vetoes for the first time in U.S. history. Imagine that. Now, what the Freedmen's Bureaus, what they were doing is they were giving land. They were giving land. One more time. The Freedmen Bureau was giving land to these former slaves. They didn't have money. Y'all hear what I just said? They didn't have money. So the Freedmen Bureau were giving lands to these former slaves. It's a certificate right here. Office of the Superintendent of Freedmen. But guess who didn't want this to happen? Still guessing? Still guessing. I want you guys to see this. When you guys are in a court of law or whatever, there's this case. Let's see if I can find it. There's this case right here. A Medal of Honor, the United States versus Xavier Alvarez, and it was decided in 2012. The United States, the federal government said that this guy, Xavier Alvarez, he believed in himself, saying that he was a retired Marine of 25 years. And the court said that lying was his habit. He was a habitual liar. And he told all his friends and comrades that he was a Medal of Honor recipient. And the prosecutors said that he violated the Stolen Valor Act. They were trying to charge him. The states were trying to charge him. Well, the federal government said that he was a habitual liar. And so he was protected by the First Amendment in doing so. And so they gave this guy his freedom. A lot of veterans were upset with this. But hey, the interpretation of the United States federal government justice system said the guy was a habitual liar. You guys need to remind yourselves when you're in a court of law and you sitting next to, or you're being judged by a police officer, you're being accused by a police officer, and they're given these rights to lie on purpose. Again, the Castle Rock versus Gonzales, Warren versus District of Columbia. These guys are protected by government, by the Constitution, so to say, a Constitution that allows democracy to overrule your own rights. And here we are right here. Justice.gov has this immunity of government officers sued as individuals. And what are they going to do? They're going to get rid of common law. That's the first thing they're going to do. Common law, which is human rights. And human rights is the thing that Malcolm X was demanding. Civil rights is what they keep telling us Martin Luther King Jr. was fighting for. Civil rights. You want to be civil in a city. That's what civil means. You're a city right person. Well, here we are. We have this immunity of government officers sued as individuals for official acts. You're acting officially. The Supreme Court of the United States is saying that they are immune from common law. I it just gets me. It just gets me that we have a president right now of the United States that he's trying to destroy Black history. He's trying to destroy Black history. And he is creating disastrous social awareness around the world right now. He wants people to be angry with him. I think that's what he wants. I'm not sure, but he's pissing a lot of people off right now, and he's destroying Black history. And this is how we got here. They amended their constitution in order to have Black people stand next to white people. And mind you, Black people have been knowing white people for a very long time, even in Europe, and they won't say that. But what the president is doing is he's pissing a lot of people off. And sometime there may be a war that comes up. And do you know how low the morale will be when you have Black and white people in one army, and you have a law system and a justice system, a just us system, or a just this system, or a just that system, and you believe that you're going to send some people that you disrespect to go and save you, to go help you create some more quote unquote white history, and you give yourself the privilege to destroy the Black history of the people that you're commissioning? Don't make sense to me. It shouldn't make sense to you. But this is a democracy that is not even constitutional, a democracy that allows itself to lie to the people who are supposed to be citizens. We're living in a democracy that allows its officials operating in official capacity to destroy one group of people, just them, to protect the just us system. And it's really disturbing to the people who've been fighting so hard to simply stand next to other people and have the common courtesy of simply breathing around them. Just basic living. Yeah. But I'm going to end my rant today. Again, just a quick recap on, this Dred Scott decision that it basically told Black people and their descendants that they were not citizens. So they had to break their own constitution. They had to breach their own constitution. Breach it. It's a breached contract so that they can allow Black people to live as citizens. And then when we get down to the 1865 era, when they freed the slaves, they're showing us in these reports here, these United States court cases, they're showing us that they can reinstate Black codes without you thinking about it, without you knowing it, and have the ability to lie to you about it in your face. That's what democracy is. That's what the democracy of the United States is doing. And for yourself, don't listen to what I'm saying, or don't take for what I'm saying for granted. You go find this stuff out yourself. I'm just a messenger, and I'm showing you guys what democracy is. And I'm showing you Negroes what you need is a treaty. You don't need to keep on keeping on fighting for civil rights, where they can give you some rights, some civil rights for you to live in a city, and then they can lie to you and destroy you at the same time and circumnavigate over the laws that are supposedly, made to protect you. show you words. There was just one last thing. The U.S. Marshal's Office. Now, the U.S. Marshal's Office, this is the last thing I'm going to show you guys. The U.S. Marshal's Office was never given orders to stop protecting Black people. Show you guys this image. There's many of these images. There's also the Office of Interior. The U.S. Marshal's Office was never given orders to stop protecting the people from Black codes, from the philosophy of, just racism in the United States. They were never given orders to stop doing that. So just to say, you guys need to, I'm saying, Black Americans, Black people, people of color, you guys need a treaty. Fighting for civil rights in this country is just, it's a drag, and then they get to lie to you. They get to lie. They get to pull all manners of craziness against you and then be backed up by a system that's actually helping them. And then there you are trying your best to figure out, go through the maze of all these laws and regulations and to figure out and find that they only protecting themselves. Democracy only protects itself. It's like a big fish. And this is what democracy is big fish versus the small fish. And those big fish, they don't really care about your human rights. And that's all I got for today. You guys have a good one. Hebrew Israelite out.